A massive U.S. Federal Court of Appeals decision coming from the Fifth Circuit Court of Appeals. This is based out is U.S. V Rahimi. We're talking about prohibited possessors and the fact that the Fifth Circuit just struck down an entire group of prohibited possessors now is in essence being lawful to possess. Let's get into the whys and the hows, and then last, why you should absolutely care. Coming right up. So, here we go, guys. U.S. v. Rahimi. We're talking about an individual who was basically had a domestic violence injunction put against him. So, in other words, he had a restraining order against him. And then he got convicted for being in possession of a firearm as a prohibited possessor because he had a firearm while he had this domestic violence injunction against him. He appealed, winds up going up to the Fifth Circuit, and the Fifth Circuit says, look, you know what? We're going to apply New York Rifle State Pistol Association test v. Bruin. So we're looking at historical analysis. And here's a great quote, and there's a couple quotes I'm going to give you. Here's one. The question presented in this case is not whether prohibiting the possession of firearms by someone subject to a domestic violence restraining order is a laudable policy goal. It's a $2 word for a good policy goal. The question is whether 18 U.S.C. 922 sub G sub 8, that's the specific law we're talking about, a specific statute that does so is constitutional under the Second Amendment of the United States Constitution. In light of New York State Rifle and Pistol Association v. Bruin, it is not. Those are the words, with some editing, from U.S. District Judge Corey Wilson, who wrote the ruling. He goes on to note, we conclude that Bruin requires us to reevaluate our Second Amendment jurisprudence and that under Bruin, 922 sub G sub 8 fails to pass constitutional muster. We therefore reverse the district court's ruling to the contrary and vacate Rahimi's conviction. What does this all mean in English? It means that basically this law that was passed approximately 30 years ago to make it a criminal act, makes it a felony to be in possession of a firearm while subject to a domestic violence restraining order, is not part of our nation's historical firearm tradition. In other words, it's unconstitutional. It does not pass the Bruin test. It also goes on to note, in sum, our founders envisioned a nation in which both citizen and sovereign alike play important roles in protecting the innocent against violent criminals. Our decision today is consistent with that vision. Again, that's Judge Wilson who wrote the ruling. Now, of course, Attorney General Merrick Garland came out with a reply. He wrote the following. Nearly 30 years ago, Congress determined that a person who is subject to a court order that restrains him or her from threatening an intimate partner or child cannot lawfully possess a firearm. Whether analyzed through the lens of Supreme Court precedent or of text, history, and tradition of the Second Amendment, the statute is constitutional. Accordingly, the Department will seek further review of the Fifth Circuit's contrary decision. So those are the battle lines that are now going to be going up to the U.S. Supreme Court. What does this mean, again, broken down in English, and then very importantly, why you should absolutely care. In English, can you be in possession of a firearm while subject to a domestic violence restraining order or a qualifying injunction of any kind? That's the fundamental question that this is particularly looking at as it relates to the conviction. What's the broader picture issue as to why you should care? What Attorney General Garland is saying is that a law that's 30 years old is part of our nation's history. It's part of our nation's tradition of firearms regulation. So the anti-firearm people, the anti-Second Amendment folks, are trying to expand the Bruin decision, which really focused on specifically 18th, 17th, and to a degree 19th centuries. We're talking 1800s and back firearm regulation. Garland is now trying to expand that, so the anti-gunners are trying to expand that into, the 1990s. We'll use that, that works, as being part of our nation's firearm tradition. You should absolutely care whether or not the 20th century, and if the 20th century is in, where are we starting to draw that line, where that all comes part of this. I know some of you are going to be asking, Tom, what about the NFA? Is that going to be part of this? If you want to know about that, I have some thoughts, but let me know in the comment section below. If enough of you care, I'd love to be able to make a video on that. But folks, this is the reason why you should absolutely care about this case, even if you don't care about whether or not someone is a prohibited possessor because they're subject to a domestic abuse injunction or something like that. Because we're talking about the means testing. We're talking about the process and the procedure that goes into how large is the wall, how tall and strong is the wall around protecting the Second Amendment. If the anti-gunners win this case, that wall just got knocked down substantially. And rest assured, there's going to be a lot of very bad laws that are going to follow it that will be found to be constitutional, that are infringing on the Second Amendment. If this is upheld, now we're going to start to see the U.S. Supreme Court saying, yes, this is where the line is, and importantly, here's how tall this wall is as well. So guys, even if you may not care about this particular issue, you should absolutely care how the courts are making their rulings, because rest assured, it will come home to roost on an issue that you do care about. If you also care about this channel, show us some support. Click subscribe, show your support for the Second Amendment by clicking like. Let us know in the comment field below what you think about all of this, where you think this decision is going. And of course, any and all comments, we'd love to see them, we'd love to hear them. And guys, we'll see you in the next one.